What's up, everybody? Good morning. Good Friday morning. Happy weekend. We're going early today. First off, because the video posted last night of this hearing on Kohberger's motion to dismiss the indictment. We got some info on what's going to happen with the cameras. We got some IGG info, what's going to happen with the DNA. So some of our questions have been answered, some still to be answered. This motion hearing has an answer at the end. The judge makes a decision. It is the decision we all expected from the jump when we first read this motion, but the judge's comments about the motion I found to be pretty interesting. And I think that he's showing his impartiality, that he is going to listen to both sides, listen to the arguments, and do what he can to make sure this is an absolutely fair and transparent trial and case. So we're going to listen to the judge's rulings. For the most part today, I am going to a golf tournament in Orlando as soon as this video is over. So we're going to get as much done in this video as we can. So many of you, there's so much going on, right? So much content to be discussed, which is why it's hard to, really dig in on so many cases. But I got a ton of questions about the crazy stuff happening in the Delphi case. So right after this, we're going to redirect to about a 10 or 15 minute discussion on my thoughts on what the heck's going on with the lawyers and the judges and Richard Allen, the Delphi case. So if you guys want to stick around for that, we'll auto redirect to it. And then at some point, I'm trying to do a reaction to Sally Smith's proffer in the Maya case. We'll see if I get around to that. But this to me is some huge news in Kohberger, because we have found out now, I did a short on it yesterday, cameras are going to be in the courtroom. The judge is going to take more control, and we'll see his comments on this motion dismissed kind of throughout the hearing, and that I think he enjoys the way Jay Logsdon argues and writes these motions, and potentially, while it may not have won the day in this hearing, in the future, we'll see if that has some kind of an effect. So we're going to watch the hearing in its entirety together. We're going to talk about the judge's comments, and of course, I'm going to answer your questions, which to me is the most fun part of the video. So make sure you get your questions in. I will be looking as I'm pausing and starring questions and coming back to them later. Thank you to the new members that have joined, Cheryl and Dorothy. And if you guys haven't yet, hit that like button. Azam has gifted a membership. That's always fun. We're getting close to 300,000 subscribers, and we're going to have to do something fun when we get there. So hit that subscribe button if you haven't already as well. Nicole said the Sally Smith proffer had me all kinds of angry. Yeah, it was something. And I got to be honest with you, that's not so unusual for doctors to act like her and disregard so many things. But again, we'll save that for another video, because today we have a hearing to watch. There are currently cameras in the courtroom, and it's on a delayed feed. Doesn't bother me that much. We still get to watch it. We still get to see exactly what happens. We don't have to rely on reporting. And I think really what's important about these cases is to discuss it in a fair and impartial way. I said this in the short as well. Let's make sure we handle it respectfully, that the cameras are still going to be in there, and let's this community and as many people as we can talk to and have an effect on in YouTube handle it respectfully and in a way that would make the judge proud that he's letting the citizens of our country and even around the world watch this trial and not the other way around. By the way, I am wearing some lawyer swag on the golf course today. We are the blue team, so it just kind of worked out for me. My church does a Ryder Cup style golf tournament every year, and I'm on the blue team, and so I get to wear lawyer merch. All right, let's get to the hearing.
A couple of things I just want to share. Number one, I apologize for the delay. It was supposed to start at 1 o'clock. The hearing that started at 9:30 went a little long. But it was important. You're probably wondering why it was sealed compared to this part of the hearing, and that is because we were dealing with the procedure of the grand jury, the procedures of the grand jury, and a lot of details, and the grand jury is secret. So that's why it's sealed, and whether you like it or not, it's baked into our United States Constitution and the Idaho Constitution. So there's a reason for that. I advised camera people not to.
So that was just the first hearing that happened in the morning. This is the second hearing of the day, was under seal. And the reason is because they were discussing grand jury proceedings, which are secret. So it wasn't anything like crazy going on or shady or anything like that. But when we're talking about specifically the procedures of the grand jury, that can't be public. That's a nationwide kind of thing. So that's why it's sealed. Deb N gifted a membership, and then Nicole dropping 20 memberships. So make sure you have whatever you got to have turned on to accept a gifted membership. Danya, I'm not quite to 300K yet, but we're working our way there.
Turn on the cameras until I was on the record, and they turn off when the record is off. I just want to remind you, you just heard Matt talk to you about not having your phones, your laptops to film anything, to record anything. That would be a violation of the rules, and we will take away your laptop or your phone. Some of these rules have been violated in some of our hearings, and I have an obligation to put a stop to that. And I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint. And some of that I've heard or seen has been disappointing. Just so you know.
So what's interesting is cameras are staying. He's not banning cameras. He's taking more control over them. Maybe the positioning, what they can see, what they can hear, whether they can see anything at counsel table. He's going to try and fix some of the issues. He also said he is going to allow, cameras and cell phones in the courtroom now with the people that are sitting there, which he did. But he said some of those rules have potentially been violated, and he's reminding people they're violating a court order. So potentially they could be held in contempt if they violate those rules. And he can be stricter on the people in the courtroom with phones and cameras and things like that if he's allowing cameras in the courtroom. So it's kind of like having cameras in the courtroom eliminates just about anybody's arguments that, oh, this isn't fair. He's closing this off. He's not allowing us to watch a report on it. Cameras in the courtroom pretty much eliminate all that. So if he was even more strict on the people that are actually in the courtroom, it wouldn't surprise me. But he right now is trying to do the balancing act, which is really a judge's job. Balance, make it fair for everybody. Try to make everybody win when you can, or just lose a little bit. And I feel like that's exactly what he's doing at this point. I think he's doing a good job of it. Welcome, Allie and John. 5 memberships from our painter, our favorite painter. All right, let's keep listening.
Yesterday, I issued an order addressing IGG DNA, and there's going to be an order for in-camera review that I'm going to go through. In-camera does not mean anything about a camera. That just means I look at the information before I can share it with the defense.
So I haven't seen the actual order yet, but he says the IGG, the DNA information that the defense has really been fighting for, and giving expert opinions on and really pushing to get this IGG information that the state is really trying to block. He says he's going to do an in-camera review. Nothing about a camera, just means back in chambers, just he looks at it before it gets turned over. So usually judges can look at it before they actually make the final decision as to whether or not they're going to turn it over to the defense. So one of the things the judges do when they have that in-camera review is they take all of the notes that they have, the expert testimony on how the defense is going to use it, why the defense needs it. They look at it and they see if it's actually that. So if the defense says, well, this is going to give me information about colors, and you look at it and all it says is information about numbers, well, you're going to say it doesn't even give what you've asked for, so no, I'm not going to turn it over. But if it does have the colors in there and the judge is leaning towards giving it over, then he'll say, okay, the colors are in here. I'm going to let you go ahead and look into this. So it seems like he's leaning towards giving at least some of it over to the defense, but he wants to look at it first. And he even said, I'm going to look at it before I share it with the defense. So we'll wait to see if he actually does turn all that IGG stuff over. It's probably going to be confidential and sealed and all that. But it seems like it's moving towards the defense getting that, which is kind of what I thought was going to happen in this case, but you never know which way it's going to go. Lady Lysandra said, Judge looks stressed. Rebecca said, just ready to leave work for home on glare ice. Wish me luck, lawyer, you know, family. So it's icy roads out there. Yes. Let us know if you get home, Rebecca, safely. We hope you do. And Rebecca's going to give 5 memberships on her way home.
Let me see, what else did I want to kind of share with everybody?
Also, by the way, cameras protect the judge as well, because we see, just wait till you hear some of the accusations against the judge in Delphi happening behind closed doors and how she's going to act one way behind closed doors and one way in front of the cameras. Judge is like, I want to just share everything out here in the open. So it does protect the judge a little bit as well. Cowboy asked, is it normal for the prosecutor to withhold evidence from jurors on the grand jury? So yes, they don't have to present everything. They just have to present enough to prove probable cause. Now, if they do withhold certain things, it could be problematic. But they never share everything they have with the grand jury. I shouldn't say never. Rarely do they share everything.
I think that's about it. So we're here now on the defense motion to dismiss indictment on grounds of error in grand jury instructions, or in the alternative, remand for preliminary hearing. So Mr. Logston, I believe, is going to present the argument. Thank you.
So this is the motion that went all the way back in time, saying the probable cause standard is wrong. It should have been beyond a reasonable doubt. And if it was beyond a reasonable doubt, they would never come to this. And we need to go back and have a preliminary hearing because that's really the only fair way. So that's what this argument is, that they're going to now present orally to the judge. This is Brian Kohberger's defense attorney, Jay Logston.
I wrote a lengthy brief or two on the subject of where we're supposed to be legally with our grand juries and where we actually are. And as Your Honor let me know this morning, probably not going to change your mind, because the Idaho Supreme Court has, I think the court thinks, not going to.
So the judge has kind of already let him know, because of the Idaho Supreme Court and the rulings they've made, he's probably not going to change his mind, and Logston's probably not going to win this motion. Now, if you take a look at what's left in the video, as I was watching this when it first came out, I didn't know how long his argument was going to be, but there's 45 minutes. Logston takes about 90% of that time making his argument still. So we are going to hear the full argument here, and the judge's comments are really interesting.
So I guess I would accept that kind of ruling as long as the court agrees with everything else I have.
I don't know.
But
I don't know about that.
assuming that you don't, let's, I guess, just kind of walk through the simple steps here. So at issue in this particular case is Idaho Code 19-1107, and the infamous language in it that says that grand jury ought to find indictments and all evidence before them taken together, unexplained or contradicted, would in their judgment warrant conviction by a trial. And the first question that a court has to ask is, what does that mean? And you start with the plain language, which we argue. What warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books, or back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what.
It's funny when he says stuff like it's clearly more than probable cause, knowing he's about to lose an argument. But he makes the point again that if they say something that's enough for a trial jury is beyond a reasonable doubt. That's where he gets the connection and the arguments he's going to continue to make.
And the state has pointed out that if you look at really old light dictionaries, it looks like the word warrant means what you might think it does. Old timey folks, at least it does to us, that if it warrants doing something, it means that it would permit doing something. So the plain language seems to support what we're saying. And the biggest problem that I have then is just that obviously everyone in the country disagrees with me, from sea to shining sea. And so I'm now put in a position of trying to explain why that occurred and why, in the year of our Lord 2023, we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer for that, other than I think the only time I ever heard about field codes before I was looking into this was like a really short moment in a class that I took back in law school. So, I mean, it's somewhat famously kind of the first attempt to codify the law of the day. It takes place in New York and spreads across the country back in 1850. And I think what I read in the tea leaves from the New York decisions and the later California decisions is that there's pushback at some of the things that the field code is trying to do. And one of the things the field code very openly said it was trying to do was fix the grand jury system. Because the grand jury system was believed to be essentially broken. For a lot of the same reasons we don't seem to like grand juries very much today. It was essentially believed that grand juries were hard to control. Grand juries would essentially always favor whatever it is they were told and would always indict the accused. And so as a system to protect people, it didn't seem very protective. And they pointed out in the bill code, if you go back and read it, that essentially the secrecy aspect of the grand jury is both its most powerful sword and its kind of its worst aspect at the same time. So you just don't know what you're going to get out of it. And so they create a bunch of stuff.
What's interesting is, so as somebody who practices mostly on the defense side now, as far as criminal goes, the secrecy being a bad part about the grand jury, I somewhat agree with that, but also it's just to find probable cause. So in certain crimes, right, and a lot of crimes, just one person, a judge, just finds probable cause. Or they could have a preliminary hearing where, again, they present it to the judge and the judge finds probable cause. In this case, you can do either. In some situations, it only goes to a judge. So the grand jury is not the end all be all, which is the same reason why the trial court and those juries are not fully secret, and that process is not fully secret. In fact, it's being broadcast all around the world, and that's why it's so important, because that is the end all be all. I know there are appeals, but very interesting. And Paula said, before I joined the lawyer, I never realized how much goes on before trial even starts. Thanks, Peter, for all your guidance. Thank you, Paula. And yeah, a lot. The vast majority of the case, it's like an iceberg. The trial is just the tip of the iceberg. Underneath is everything that happens before the trial in most cases. Salty Beach Girl Lori said, is there a new date for this trial or still just floating? As far as I know, it's still just floating. Once you waive your right to speedy trial, all that stuff can start to get delayed. Rebecca said, roads are worse than I thought. Gotta love North Dakota. All right, well, focus in on that. Drive safe. Let us know when you get home.
That start to rein in what grand juries can and can't do. And they create some scenarios under which grand juries can be reviewed. And they, in the New York, they call it the Court of Appeals, it's their Supreme Court, says, even though we have these statutes that say we should only set aside these indictments in these particular moments, clearly there's got to be some sort of a due process protection. If you're going to pass a bunch of statutes that rein in a grand jury, you can show that somebody's not following those to the prejudice of the accused, and that's going to look for dismissal as well. And that doesn't seem to be very controversial. We see similar language in that, FAR case that we talked about in the state of Idaho, which I think dates to like 1913 or something along those lines. But at the same time, while the state of New York is trying to figure out ways to not have to abide by the language of what would warrant conviction, by essentially saying, if you can tell the grand jury that is their burden, you can also tell them the probable cause thing, as long as they hear both of it, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. It kind of moves the whole situation to obviously there's a statute. Our situation.
And that's kind of why you're not going to win, because the state Supreme Court has clearly already stated probable cause is the appropriate standard.
Is such that we have this thing on the books. And the only group that seems to really dislike it is our Supreme Court, who keep having these opinions where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, and they finally say, look, we passed a rule. I hope it's clear now. Stop saying that your burden is beyond reasonable doubt.
Yeah, I disagree with major parts of his argument. I don't think that's how it went, but even if it is, your state Supreme Court having a major issue with how something is done is more important than what just state prosecutors are doing actually in the courtroom, because they're the ones that help interpret the law. And so that's an uphill battle. Lady Los Sandra, I believe Ann Taylor would have done a better job. I think they're splitting it up to what their expertise and their strengths are. And I think she's focusing on a lot of other things. So I think Logsdon is focused on issues like this. So I think he's just had more time to research and prepare for it. I don't think he does a bad job. It's just a losing argument. Rebecca said, going from saving a 2-year-old to choking on a peanut to just driving on black ice. What a life. It's a roller coaster. It's a roller coaster. But that 2-year-old's lucky to have you. Tom, hit him long and straight today. Look out for the groundskeeper with that rangefinder of yours. LOL. I will. I will do a great job of that. And this is like one of my favorite tournaments all year. So I'm hoping to go low. It's a 2-man scramble. So wish me luck. I'll let you guys know how it goes.
Well, as the court knows, the way that those rules get created is a bunch of people that get invited to parties, and like me, in the legal community, go and are selected to sit in a room and decide what those rules should say. And there's quite a bit of the time it seems like the Supreme Court will later have an opinion and go, this is weird. Why is this one of our rules? And so simply,
he said the way these rules are written is people that get invited to parties, unlike me, sit in a room and try to figure out what it is. It's not a party in the rule writing world for lawyers. It's lawyers who grind over these and fight about these rules because they know how they apply. They have experience doing it. It's where they live. Literally, the rules I help write in the Civil Rules Committee, it's all a bunch of civil litigators who deal with these rules, practically know how they work, look at the history, look at old rules, look at comment sections, look at what the Supreme Court says, what all the higher courts say, what other states do. A ton of research goes into writing these rules. Now, sometimes the Supreme Court of the state will just throw stuff at us and shove it down our throats, and we don't have a choice, and we've got to write it the way they want it or change it and try to make it the best rule possible. But sometimes they will overrule us, which is kind of within their right, and we can fight about that as the Rules Committee. But to act like the Rules Committee is like Alec Murdoch and his buddies sitting around at a conference, drinking while they're writing the rules is not really true. Parties happen. Drinking happens, hangouts happen, golf happens, but we are locked in a room for 4 hours multiple times a year as a full group trying to write these rules. And we have all these subcommittee meetings where we meet for an hour, we argue with each other, we fight with each other as a subcommittee. But then when we go present the rule to the full committee, we're usually united. We know what the vote is. We can have a dissenting opinion, but it's a full process. And it's not easy to write rules. It's definitely not easy to change rules. And it's not as flippant as he's making it sound here. I'll just say in my experience in Florida being on rules committees, and you do have to get appointed to a rules committee. You can't just say, I want to be on a rules committee and be on it. So to that effect, yes, there are selections made and certain people get on rules committees and certain people don't. So I don't want to make it sound like that's not true. But we have in the criminal rules, we have public defenders and state attorneys. My dad's always on the criminal rules procedure, making the rules in Florida for those. Pete's been on them. Pete's been on the rules of evidence, things like that. And there are prosecutors and public defenders on there as well.
they say that, well, because the Supreme Court wrote it, that's their opinion on the matter isn't quite accurate. But clearly, the Edmonton court was behind that as a concept. At the same time, nobody was arguing with them about it. Nobody argued about the issue until just now. Well, that's not quite accurate. Obviously, Mr. Nosco raised this in a few district court cases up in Virginia. But nobody's really been digging into this or raising it until this time. So when the court says, look, the Supreme Court's already got a rule on this, Supreme Court's already ruled on it, it's just not true. They have never ruled that probable cause is the basis because there was an argument about it. And they said, no, you're wrong, that's probable cause. That hasn't occurred. They ruled a lot of things, but that's not one of the ones. And the fact that they adopted a rule that says something that they believe doesn't necessarily set in stone what the law is, or for that matter, what the Constitution is to say about it. So the big issue, I think, at least my favorite issue here, was can the Idaho Supreme Court override the legislature and lower the burden of proof for the country?
And he says that as if it's a fact that the legislature has set the standard of proof at probable cause, which I mean, beyond a reasonable doubt, which I don't agree with, and I don't think the judge agrees with either. But either way, the judge overruling something that's very clear from the Supreme Court is a surefire way to get overturned on appeal. So why would the judge do that? Allie asked, hope this isn't a dumb question. Richard, I'm glad you're here as well, by the way, from that prior comment. I hope this isn't a dumb question, but can this judge even grant a motion to drop the grand jury indictment? Yes. Yes, there are scenarios where the judge could render the grand jury indictment null and void, dismiss it, send it back to preliminary hearing, or dismiss the case and make them refile and go before the grand jury again. That is possible, but it's not going to happen in this situation. Salty Beach Girl Lori, Peter, you're the only one I could ever manage before being caffeinated. You're always so level and explain easily. Have a great tournament. Thank you so much. I'm getting caffeinated currently right now.
that was a tricky one, because we don't really have a case that just comes out and says that the burden, or for that matter, I guess I don't know, we got this all kind of mixed up when we were doing the argument. So the burden of proof, I think we decided was actually who has to show something, and then it was the standard of proof was the amount that has to be shown. But everybody confuses it all the time, and I'm using it right now as well. But I'll call it the standard of proof just to be less confusing. In any case, the standard of proof.
In his head, he just kind of went through the difference between the burden of proof, which is who has the burden, who holds the burden, who has to prove it, and the standard of proof, how you have to prove it to beyond a reasonable doubt. All that stuff is the standard of proof. People call it the burden of proof. It actually is interchangeable. As he just said, I guess I'm kind of confusing the issues during this argument as well. It's basically interchangeable. Everybody knows what we're talking about. And everybody usually knows who has the burden of proof. And then you explain what the standard of proof is. But it was just kind of funny to hear him kind of go through that discussion in his own head.
Is that something that the judiciary has power over? In other words, is that simply a procedural rule, or is it a substantive rule of law that courts can't mess around with? And we argued, it cannot be that if the Supreme Court woke up tomorrow and declared that the standard of proof in our cases was something beyond reasonable doubt in trial cases, that we would also say, oh, well, that's what the courts can do. Because if you read those cases, what they talk about is that that is a right, a due process right, essentially, of the accused that is set by the Constitution, right? That's what Interet Winship. It set the standard via the Constitution, locking in the standard of proof that's required for a conviction. And so when we talk about these standards of proof, it is true, obviously, that if you look at the case law, you'll see courts setting a standard of proof for their own evidentiary rules. But you don't see it in many other places. What you see them doing instead is having somebody come in and say, well, the legislature set the standard of proof, but we think you should make it higher or lower based on, and most nobody ever says, well, it's always higher. And we're always arguing that the Constitution clearly must set it in at some higher point to protect people, and then the courts leaning in and saying, well, we don't see any particular reason why the legislature messed this up, or if you're in the United States Supreme Court, occasionally you say, well, we do think that this is goofy and we're going to raise it. Okay? I couldn't find a case where the Supreme Court or anybody else leaned in and said, we think that the legislature is being a little too protective of its people here, and we're going to move down the standard of proof for the government in this particular case, or one party versus the other. Typically, in this country, we're trying to protect the accused, and we believe that those protections are given to us via the Constitution and via these concepts of due process that come to us with common law, which is where this gets so messy, because the common law would tell you that it's probable cause, and it's some guy named Field in New York telling you it should be something else. Well, we could get into all of that, but it would be, I think.
And again, he's really confusing some arguments here, I think, to try and make his point. I understand where he's trying to go, but to say that this doesn't protect the accused due process rights, I disagree with. I think there's a lot of protections in place. A lot of you guys sometimes get frustrated with some of the protections, even during the Darrell Brooks trial, and we hear some of the protections, but probable cause versus beyond a reasonable doubt in the grand jury proceedings that are secret, that just a prosecutor presents an argument, there's no defense attorney there, I really don't think it would make that much of a difference. I talked to my buddy who was just on a DUI trial the other day, and they didn't even really discuss what beyond a reasonable doubt was versus any lower standard. It's like they kind of pick who wins a lot of the time. And in a grand jury, prosecutor almost always wins. So whether or not the prosecutor is explaining beyond a reasonable doubt versus probable cause, I'm not sure there would even be a difference. So you kind of got to pick your battles, because next it would be, well, defense attorneys need to be in a grand jury proceeding. And then you kind of change what the grand jury proceeding is altogether. So it is interesting to me. Tom Hubble said, it's great that lawyers give of their time and talent to be on committees. It is important because you're taken away from work time. They're literally 4 to 6 hour blocks. Some of these committee meetings and then multiple subcommittee meetings. So it is an interesting, donation of time. Salty Beach Girl Lori, my freshman in college, wants to go to law school. He's a poli-sci major. That's like the most common one in law school. It was yours. Mine was sport management. Would I pick it again? Yes, because it was pretty easy. I think business potentially might be what I would pick just to help run a law firm, maybe advertising or marketing, because that's a big thing they just don't teach you in law school. Poli-sci is probably not my favorite. It was kind of hard for some people, and they didn't get as good of grades in it as I did in sport management. It was just so easy, and GPA and LSAT is like the most important thing, and I did well on the LSAT, well enough, I should say, and had a good GPA, so law school getting into it wasn't an issue, but sometimes you pick a hard major, and that can become an issue. Another off-topic comment. Ann said, "I love the channel. Off-topic, your Bucks. Sorry about your Bucks, Peter. Buffalo native. Pretty happy this morning. Yeah, I didn't expect to win." And last one, Vanessa. Sorry to say here, but me and the family are over the moon. My daughter and son-in-law just adopted a baby girl. She's so very loved and wanted. Who wouldn't want to start their morning with a comment like this, Vanessa? That's awesome. Congratulations. I'm so happy for your family and for their new baby girl. John, how important do you think the IGG info could be to the case? I feel like if the evidence was beneficial, why not just release it? Thoughts? Thanks, my guy. Yeah, John, I don't know. It's so complex and complicated. I definitely think the defense is going to find something to use in it, but how big of a deal it would be, I don't know. Kind of like a lot of cases we talk about, maybe it's just going to be enough for the defense to kind of cancel out in the battle of the experts, and not make it as big of a deal to the jury as the state wants it to be. But it's hard for me to answer without knowing what it will actually be.
More philosophical than anything else, because the state of Idaho didn't do it that way. The state of Idaho, as a territory, adopts a bunch of codes out of California, a code that they've already looked at, a code that they've already said, these words clearly mean something more than probable cause. This is what you're adopting. If you come and get it, the state of Idaho goes and gets it and adopts it. So that's what the state of Idaho is adopting. I obviously recognize that the founders that wrote the Constitution did not appear to recognize what was already on the books in this regard. However, just because they didn't recognize that doesn't mean it's not still part and parcel of what was thought to be true by a large portion of the citizenry of Idaho who had actually ratified the document. The only thing we know is that from 1890 to Edmondson, the Supreme Court of Idaho was repeatedly admonishing prosecutors to stop using a beyond reasonable doubt standard for a grand jury. And that, it seems to me, is pointing to this concept. I mean, we're going to talk about common practice. Common practice looks to have been that everybody thought the standard for a grand jury was beyond reasonable doubt. And I don't think this is like worthy of the parade of nightmares that I've been reading about. Obviously, in each one of those cases, the prosecutor was able to pull it up, and little wonder. I mean, it's still a grand jury proceeding. It's still just the prosecutor in a room with 16 citizens, 12 of which have to agree. They get control over basically everything that's being put on. I mean, the guardrails being put in. Hey, let's use admissible evidence. Hey, let's not pull in hearsay witnesses. That kind of thing is not going to somehow make this impossible and make it so that it can't possibly work. What it's intended to do is just make it so that if you're in a position to get an indictment against somebody, you're going to put on your A game. Obviously, we've been talking a bit about how we don't think that that's what occurred in this particular case. And we certainly.
Well, what's interesting too about this whole discussion, and Lady Los Sandra asked, how does the standard of proof for a presentment differ from that of a grand jury? I think it's all just probable cause. But to change this to beyond a reasonable doubt would make it, the less beneficial choice for a prosecutor than to just go for a preliminary hearing in front of a judge. But do we want it to be like that? Because a judge understands the process better than a grand jury. So a judge can use probable cause, but a grand jury would use beyond a reasonable doubt. Do we also need to add a defense attorney into the grand jury process? To me, they're trying to edit the grand jury process than what it is. And I wouldn't be opposed to editing the grand jury process, but this is not the way to do it, just to argue that we've been doing it wrong forever, as opposed to we need a law change. Let's change the way grand juries are done. Let's start doing it like this, because it wouldn't send shockwaves through the legal system and how everything's been done for, forever. Lady Law Sandra gifting a membership as well.
I really don't think that if the court were to adopt this in this particular case, that this would even remotely cut the mustard, because we know from the grand jurors that at least 6 of them wanted to hear more until they were essentially cut off and told probable cause of the standard and what people do it.
You probably should cut that, what the grand jurors did or didn't do.
Fair enough. But
So I've been saving Jesse's comment. You know what they cut out? The fact that there were 6 grand jurors who wanted more evidence, and they basically said, too bad. And the judge said, we'll probably cut that part out. It was being tweeted out. I saw reports of this as well. They didn't cut it out, at least not of this video. So we heard him say 6 of the grand jurors said they wanted more. And he said, let's cut that out. So here, let me just play devil's advocate, but also try to be fair here, because I want to know what's going on. I want it to be transparent. This is, if I'm listening to J-Logs and make all these arguments, a lot of it sounds good. Like I said, when good lawyers make arguments, you should be on their side. But reading both sides and reading some of the case law and understanding how probable cause works and how grand juries work, I don't think he's specifically correct on some of his arguments. Doesn't mean he doesn't believe it. I would just disagree with him on certain things like the judge does and like the prosecutor does in this case. So this is just one person's interpretation of what 6 grand jurors said. The other side did not have the opportunity to respond, at least publicly, because the judge said we cannot talk about what the grand jurors did or didn't do. That is sealed. That was for the prior hearing. They may have discussed it already, and that's why we didn't hear a response. So did they say we refuse to make a decision? Did they say we don't think we have enough or beyond a reasonable doubt? And they had to be reminded, oh, it's just probable cause, not beyond a reasonable doubt. And that's why they made their decision, which is correct. They do. That would be like a trial jury saying, I can't decide this case beyond every shadow of every doubt, 100% certain I can't decide this case. And the judge reminds them, well, it's beyond a reasonable doubt, not 100% certain. That would be appropriate because that's the appropriate standard of proof. You get what I'm saying? So I think it's important not to conflate issues that if they thought they needed more for beyond a reasonable doubt and then were reminded of the correct burden or standard of proof and then made their decision, I think that's appropriate. Now, if it should have been beyond a reasonable doubt, then I agree. No shot. If this was a trial jury, I think it'd be an issue. It would be a difference if they didn't feel like there was enough and then they were kind of forced into making a decision. But on a grand jury, I do think it's a little bit different. But I wanted to make sure to point this out because Jesse did point out it was a good point. And I did see it tweeted out, but they left it into the video. And I think Judge didn't say cut it out because I don't want people to know that. He knew people sitting in the gallery were going to hear that and tweet about it and talk about it. He just doesn't want any grand jury proceedings that are supposed to be secret to get out. And I think that's fair and appropriate.
I'm just pointing out that there's clearly prejudice in the record that the court can see from what they want to demonstrate. It's also, as we argued, clearly going to be fundamental error. You tell the grand jury that this is the standard and it's actually something else. You can't possibly think that the result that you're getting is the accurate one.
I agree with him. If you tell the grand jury the wrong standard, then that's a problem. But that's not what happened here. They told them the right standard, I believe.
So you have to do this. These are fundamental rights that people have. So clearly that would be legal.
Right, but you just agreed that the court and case law, going back to at least Edmondson, have the standard as probable cause. So, to just say, well, they were given the wrong instruction is not exactly the case. I mean, that is the standard that has been used in Idaho for years, maybe 100 years.
Correct.
It was different. It was different there for a period of time, but after Edmondson, I thought that it was pretty much settled. Now I understand the argument between substantive and procedural, and that's that can be a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction throughout the state.
Well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life because I've spent much of it arguing that things that everyone in the state is doing is wrong.
True.
And
So he basically just said, everybody's doing it this way, so it must be right. And the defense attorney's like, well, I spend much of my life arguing that much of what the state does is wrong. Technically, partially true that we do argue every case gets to court because 2 lawyers disagree, 2 clients disagree. That's why we have judges and juries to make decisions. But not everything the state is doing is wrong, at least not in my practice or my life. So it is kind of an interesting comment, just kind of funny. But it's different to say you think the state handled this incorrectly, or even that you disagree with the law, but you understand you have to follow the law. We literally tell jurors that every single day. So we as lawyers can disagree with the law or think the law should be written a different way. And if it's not, too bad. We have to follow the law and abide by the law. I tell my clients things all the time, like, this is totally unfair. They shouldn't be able to get these medical records if, you're arguing about this, but that's what the law says and that's how it is. And we've got to abide by the law, whether or not we disagree with it. So we can't just come in and say, we disagree with it, therefore you should throw this out. We can argue against it or why it might not apply in this place, but it's there in this case, but it's very different.
occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So
that's fine. You can make an
But that's not the same thing. To say this guy's right and my client walks out of prison, that means you win a case. That's great. To say that, this picture that you think is my client actually isn't, and the state says, yes, it is. And then you have a witness testify, no, it's not him. This is him. They're like, oh, okay, this guy was right. That's very different than saying for 100 years, the Supreme Court is wrong and we shouldn't listen to the Supreme Court, and this is the actual standard of proof. That's very different than being right and getting someone out of prison or winning a trial or, proving someone's innocence, whatever. Very different.
Argument that something should change, but are you telling me that other places in the state are giving a different instruction that it should be beyond a reasonable doubt?
What I'm telling you, Court, is that it appears that up until 1980, that was true. And so the Supreme Court enters its rule, sort of has this ruling that talks about that, but nobody's arguing about it because they don't have access to the internet, and nobody has a copy of the field code or what California was up to.
Well, Justin Weislein argued about it in a dissent in Edmondson.
And we thank him for it, although.
Okay, but
If
you
you
can't
go
say
back-
that there hasn't been an argument about it.
Well. No. If you go back and you read what Justice Weislein did, Justice Weislein didn't know about the field code. He knew it came out of California. He knew that it meant something different.
I think it's attached on the dissent.
That's
Some of that.
No,
Oh,
California.
those are earlier. Oh, that's the earlier session.
He has the California code, and he has the stuff from the territories. That's what he's got. But he doesn't know. I mean, if you read the field code, apparently nobody did, except, Justice Field in California. If you read it, it literally tells you what it's trying to do. It spells it right out. And you can find it for free on Google Books, which is where I got it. I don't have a copy. I'm not even sure where you find it, but except for Google Books. You can find this thing, and they have a whole preamble to how they're trying to save the concept of grand jury. They want it to be better than what it is. They understand people have concerns about it. Let's make it better. And it gets adopted in California, and then we took it from that. And then that's what I think should matter. And the fact that the plain language of the statute is being read by every prosecutor in the state up until the 80s when the Supreme Court finally gets them to stop, because the statute's relatively clear. And so the only person who's pushing back against this are these Idaho Supreme Court justices who don't like it. But there's nobody coming to them and saying, here's a copy of the field code, this is where this all comes from, this was the point. Instead, there's just this concern that who could possibly want such a thing? How would we be safe if our communities are only able to indict people beyond reasonable doubt? It's just too much. It's too high a stake. That's hard to believe if and how many of these cases are making it up because they were convicted. There's no reports anywhere that I was able to find that in the state of Idaho, all these prosecutors were mistaken and using beyond reasonable doubt. There's just no indictment. Nobody was going to prison. Nobody was getting death. It's a free for all, and we had posses riding around and having to deliver justice because the standard was too high of the grand jury proceeding. But that's not what was occurring.
I agree with him. If it was beyond reasonable doubt, I don't really think much would be different. So I do agree with that argument that it's not like it was total chaos when I guess apparently they were using beyond reasonable doubt way back when. I see a lot of comments about jury nullification. So Tony is asking, a lot of people saying it's a right. A lot of people saying it's the duty of the jurors to do this. So here's what I will say. It is absolutely improper, unethical, and you can be sanctioned and you can lose your case and cause a mistrial if you as a lawyer ask a jury to go with jury nullification and disregard the law and make a decision on something else. Now, sometimes lawyers get into the gray area and they maybe infer it here or there. It absolutely does happen where jurors do it. It is not a right of the jury. It's not even a duty of the jury, but it is something the jury can do. Okay. So, but I would say if they come out and do interviews and all this stuff and they say we totally disregarded the law, we knew that he did it because of this, that, and the other, but we said no because of that, that could create some issues. So jury nullification is usually more of a thing where it seems like that's what happened because it seems obvious they proved the case or didn't prove the case. The jury nullified and said, forget it, and made a decision based on something else. So it does happen, but it's not something a jury's ever instructed to do. It's not something they're told they can do. It's not a right. It's not a duty, but it is something that happens from time to time. Hopefully that wasn't too confusing of an explanation of to what jury nullification is.
What you had was a perfectly well-running system, but you had
A perfectly well-running system. Interesting for a defense lawyer to say that.
If somebody had come to them and said it, we'd have a ruling, but nobody did. In fact, we don't have really any state that's ever done the heavy work of this. You've got the New York Court of Appeals, is about the only one that was aware because it happened there, and they've kind of let it drain away over time. Well, other states can do what they want. They can pass new statutes. The constitutions are older than ours, etc. Our Constitution was written in 1890, so it's now locked in what the people thought that they had as their law and what they considered to be their standard due process at that time. And the only history we have is you've got the Supreme Court saying you don't have that right. You got a bunch of prosecutors of all people thinking that we can. And that's what you're looking at. The fact that the rest of the country is off doing other things, I don't think necessarily matters. What matters in terms of the courts has to read plain language of statute. The court has to consider the fact that, at the very least, California knew what was up to, and that even if the people who wrote our Constitution didn't know what was going on, that doesn't mean that the people who wrote the Idaho revised statutes in 1887 didn't know what they were signing on for. And whether or not they were sitting at constitutional conventions is something that I put enough effort into to figure that one out, but I don't think it necessarily answers the question. Anyway, I think the only other thing I wanted to touch on was how
It is pretty wild how long he goes on this argument knowing he's going to lose. I have to say that. It's wild how long he goes on and on and on. After in the beginning mentioning he knows he's going to lose, in his motion he mentions he knows he's going to lose, and the judge is basically giving every indication he's going to lose, and he just keeps arguing.
by agreeing with me, the court is able to save the indictment by turning it into a presentment. As a presentment, there's a lot laxer evidentiary rules and everything else. Much of the complaints we would have about it essentially disappear, and the state has its presentment. And as far as I'm told, one of the reasons why we had a grand jury in this case is because in another case, I'd argue that if you don't do a grand jury, you can't have the death penalty, which I still believe. But if you have a presentment, that's also listed. And so the state still gets what it wants. And we get a preliminary hearing, which it seems to me would be worth the candle for us.
I think there was some instruction about present for the grand jury, was it not? They were given that option.
Well, I think they were told about it. So I don't know. I mean, the court maybe can find it. I can't find a single presentment in the history of Idaho. So I don't know if they've really ever been used.
I don't know.
And I hadn't really even thought about what they are, what they meant until taking up this argument. But from what
I've never even looked at a presentment really, Judge, until making this argument, but it felt like it could make sense here for us. That's what defense attorneys do a lot. We do that too. We find something, it's like, oh, I've never thought about that or never used that before. Let's see if it works here. So, I mean, we know we're coming into it. It's an uphill battle as a criminal defense attorney. That's how it is. So I thought that was an interesting comment.
Tell, going back to the field code and looking at everything else in the statutes that we have on hand, I mean, essentially, it's like grand jury like. Typically, for the presentment, the idea for who is getting the presentment seems to come from the grand jury members themselves.
He's talking about it now, Lady Losandra, so we can kind of talk about the differences between a grand jury and a presentment if you want. I honestly have never had experience with it either. So it would just be reading rules like a law school class and trying to look at the differences. But in reality, he even said it's like a grand jury light, you know?
They just come in with some information about somebody, they make an accusation like it's a complaint, and then it goes off and it gets treated more like a complaint than it does an indictment. I don't know if the court found anything otherwise, but that's the way that it appears to supposed to work. Like I said, I don't know if anybody's ever done one, but I do think that
he doesn't know that anybody, and I'm not laughing at him to say like this is a dumb argument. I just think it's so funny. This happens sometimes. It's like I don't know that anybody's ever done one, but I think I can make an argument that we could.
They accomplished in the indictment in this proceeding would easily meet the requirements for presentment. And I don't think we would have any real ability to argue with it. You know, the grand jury itself can just come in and say, these are some facts.
Because they're trying to say presentment should be probable cause. Beyond a reasonable doubt should be the grand jury indictment. They only got probable cause. It should be a presentment. There should still be a preliminary hearing in front of the judge. That's basically what they're trying to argue, which again, we talked about this when we read the motion.
I heard from my neighbor, and I think that guy committed a crime, and that's enough to start the wheels of justice. And I'm relatively certain we've met that requirement. And so if the court does that, then the state still has a piece of paper that says the death penalty can be sought from the Fifth Amendment of the United States Constitution. And a preliminary hearing would be offered to give us the ability to take a closer look at this case than what was given at the actual grand jury. So, you know, and everybody can win. I do have that as an option for the court. Does the court have any questions? It looks like you might.
I might.
Does the court have any questions? Because it looks like you might. And BB McD said, for what reason would counsel keep arguing if they know they're going to lose? I don't know. Maybe he did all this research and he wants to talk about it. I could understand that. Maybe he knows there's cameras there. Maybe he wants to make a record because he knows they're going to lose and they're going to appeal it. I don't know. Those could be some of the reasons. Love your work, Peter, and good to see you jump into Rob's 200K. That was so awesome. I was pumped for Rob. He's been putting in work on this Maya trial, hours and hours of streams every night. So good for Rob, 200K, well deserved. Many more to come, I'm sure.
And your reply.
Okay.
We'll see.
Thank you.
Thank you. And Mr. Nye?
The state has a much quicker argument.
Thank you, Your Honor. As much as I enjoy following through legislative history, as a trial attorney, we usually have a shortcut. And that is we check to see if the Idaho Supreme Court has ruled on the issue. And in this case, it has.
He's like, we can go through history or we can just look at what the Supreme Court said, Judge, and we have a shortcut. Trial lawyers usually use that. If the Supreme Court says something, that's the rule. Let's move on.
So in Edmondson, the Supreme Court said, and I quote, "The purpose of the grand jury proceeding is to determine whether sufficient probable cause exists to bind the defendant over for trial. The determination of guilt or innocence is saved for a later day. As long as the grand jury has received legally sufficient evidence, which in and of itself supports the finding of probable cause, it is not for an appellate court to set aside the indictment." This court is bound by that holding. The Idaho Supreme Court applied that holding in two subsequent cases, Martinez and Jones, both cited in my brief. The Court of Appeals has applied that holding repeatedly. This court is also bound by its holdings.
And just real quick, I know people say you're with this side or you're with that side. I 100% agree with this argument. It's very succinct and quick. The court is bound by those holdings. The holding is clear what the point of a grand jury is. It's probable cause. As long as there's enough, a higher court or no court should dismiss the indictment because of that. And to me, it's done. It's over. I get it. I get why we are having these arguments. And, you know, that's what defense attorneys do. They represent their clients, but this is not going to change. This judge really cannot. He would lose on appeal. This would lose on appeal if it ever was appealed and there was any major issues. My guess is there wouldn't be. But like, this is just a judge looking to make a decision to argue with the Supreme Court. They don't like to argue with other judges, let alone Supreme Court justices in their state. So it's just not something that would ever happen, in my opinion.
The only other thing I would add is, to summarize Mr. Allison's arguments, Idaho law supports it as long as you ignore the Idaho Supreme Court. California law supports it as long as you ignore the California Supreme Court. Idaho's constitutional history supports it as long as you ignore the founding fathers. I could go on, but there's nothing to see here. The Idaho Supreme Court has ruled on this, and this is okay.
A little shot there to summarize Logson's argument in 10 seconds. All the law in these states agrees with it, except for the Supreme Courts of those states and the founders of those states. But the Constitution disagrees with the founders. It's like nothing to see here, Judge. I thought that was kind of a nice little shot at someone who likes to take shots, you know. But I shouldn't guarantee. I would be shocked if Logsdon took any offense to that with the way that he argues and writes motions. Usually, if you like to rough it up a little bit, you don't mind when somebody gives it back to you. So I'm sure he almost enjoyed that. That's how I would be. You know, I expect sarcasm back or some shots back if I'm giving shots, and I like when everybody's playing on the same field. And so that's what I would assume. That's how he responded to that.
Thank you, Mr. Nye.
Thank you.
Okay, Mr. Logsdon, do you want to add anything else?
Well, that's just not what happened. I mean, Judge, courts say things all the time. They call it dicta. When a court is listing off,
Sometimes we call it the law.
sometimes.
So let me just tell you what dicta is sometimes. Dicta, D-I-C-T-A, is like where judges will say things in holdings or in orders, but it's not actually the holding. It's not the point of the case. It's not what they want everybody to apply. And he said, judges say things all the time. It's called dicta. And the court says, well, sometimes we call it the law because the holdings that become the law, that is the precedent that we use in all further future cases, is what judges are saying in these orders. So I just thought that was kind of a hilarious exchange. The difference between, he's like, it's just dicta. It's like, well, sometimes we call it the law, the judge says, which I thought was very funny. Lady Los Angeles said, is it bad? I love to try to defend both sides. No, absolutely not. Every good lawyer should be able to, like, I should be able to go into this courtroom, get a brief from both sides, and be able to argue like I absolutely believe and think whatever brief I'm arguing that minute is right, and then go to the other side and argue that same thing and make arguments on both sides. That's different than, you know, believing a witness or the facts or things like that. But applying the law, you should be able to make arguments on both sides and applying the law. Treasure X said, I have my BBA and MBA. Can I go to law school? Sure. And you'd probably be very good at running a law firm, because a lot of lawyers can practice, can try cases, but running the actual law firm, dealing with employees, HR, health insurance, marketing, payroll, all those different things, getting buildings, profits and loss statements. You don't learn that in law school. So I do think that that's not a bad track. Pete has his MBA.
But what we're talking about when we talk about evidence is we're talking about, I mean, nobody was arguing in that case that probable cause was the standard. They were arguing over whether or not it's fair that some people get a prelim and some people get a grand jury. That's what that argument was about. And the guy didn't come in and say, oh no, I got a grand jury and the standard is beyond reasonable doubt. But that's too, I don't like that. I'd rather have a prelim with a probable cause standard. That doesn't occur in that case for various, I'm sure, fantastic reasons.
And so, as we were laughing before, he makes a good point. If it is not what the case is about, it can be considered dicta. But this dicta or holding, depending on how you want to look at it, has been cited multiple times and has been the law in place since they made this decision. So I like his argument again. He's able to look at it and make an argument that it is dicta because they were asking a different question. It's like if I said, Judge, please make a decision as to whether or not I am wearing my hat backwards. And the judge says, I can see your long hair in the back under your hat, and therefore I am going to rule that your hat is backwards. Well, he said I have long hair. So are we going to go forward and apply that to every other case that for sure I have long hair, or maybe I'm wearing a wig, or maybe he saw something in the background? The point is we're applying the fact that he determined my hat is backwards, not about my hair. Okay, that's just kind of a simple analogy for you that Logson's trying to say. So we can't just apply long hair to everything now. We can apply the backwards hat principle, but not the long hair. And the judge is saying, well, everybody else said the long hair is a thing now, and that's how it's been followed. So I actually think the long hair is going to be considered a ruling by the judge, not just dicta. That's kind of what they're discussing here.
And the same thing happens in these later cases. I mean, it gets responded to. And yeah, like I said, the Supreme Court adopted a rule, but it's never tested the constitutionality of its own rule. It's never heard arguments on these things. It's not stating a holding after an argument. What it's doing is it's just reviewing what it believes the law to be, that nobody's picking a fight about it. I'm picking a fight about it.
And you may have the opportunity to do that to the Supreme Court.
Well,
I mean, that's what you're building. That's what you're building for. Because you know that I am constrained by the.
And there you go. That might be one of the reasons. He said that's what you're building for. So maybe the plan is to appeal this all the way up to the Supreme Court and maybe change the law, change the way the Supreme Court rules on this. And if that happens and the Supreme Court changes things, then we can start to see if decisions can affect this case. But as we sit right now and where the Supreme Court stands, Judge's hands are tied. But Judge, a little wink there, like maybe that's what you're preparing for, is to go before the Supreme Court, make this argument. We'll see what they say.
By existing law. I can't just change the law as a trial court if it's established. And I would say that in Edmondson, there wasn't an argument because it was settled law. I mean, I think that's really the problem. So, of course, a lot happened from 1880, 1890 to now, but the law doesn't always just sit still. I mean, it evolves, and that may be just what happened naturally. I don't agree that the language of the statute is completely clear too. I mean, I think you can interpret it different ways, and a lot of people have interpreted it.
No matter how many lawyers sit on rules committees and write statutes, it seems like it's always hard to make it perfectly clear where nobody has an argument, because that's what lawyers do for a living.
Different ways, whether it's beyond a reasonable doubt or probable cause. And you can argue with me about that. I mean, I'm kind of baiting you about that. So,
Judge, the cases that say that are very self-serving. These are courts that are essentially openly hostile to the idea of using beyond a reasonable doubt standard. And so they make claims like to warrant really means to permit the trial jury to see it. That's not the word.
I do like how Judge says, you can argue with me about that. I'm almost baiting the argument. I like that. I like a judge like that that's not offended when somebody argues with them, or that somebody that tests them or holds their feet to the fire. Confident, competent judges don't care because they know and they have confidence in what they're doing in their rulings.
Statute. The California case gets written in the backdrop of a statute being passed in the 1940s. It says probable cause is what you're going to look at when you're deciding whether or not these indictments should stand. So it really doesn't, whether or not the grand jury is being told something else to some extent turns into a point. The reality is, just because the courts didn't like what the legislature did, and in our case, unlike California, unlike New York, but what was part of the concept of due process in our Constitution, just because the Supreme Court doesn't like it, doesn't mean it's somehow settled law because it refuses to follow it. It has to actually have a case and determine it. Now, occasionally, they can pass rules like they did, and so that's where this whole question of whether or not it's a substantive right or procedural right. But they never ruled on it. And Your Honor has the ability to look at the whole mess, the totality, and say, what is the law? What was the law in 1890? And when did it change? I don't think what the court can write is an opinion that says, well, we don't know when or how it changed, but by 1890, clearly the probable cause was this. There has to be something where the Supreme Court considers these things in order for it to be settled law in a way that, in which Your Honor would be right and say, I can't do anything about it. They've never settled this question because nobody ever brought it up. Because it's really hard to get a copy of the field code in 1913. I don't know. But
There was, I can't remember the name right, but in the 1950s, there was dicta where the judge, the appellate judge said, no, that's not the standard because they were using the unreasonable doubt in that case. Anyway, there was a discussion in that case about what the standard of proof is or should be in the grand jury. So there have been touches of that along the way, I think, but you're right. There's not a whole lot of law until the Edmondson that was pretty clear, and then as Mr. Nye pointed out, a couple of decisions after that. With that case, which I think was 1987, something like that. So, yeah, I mean, I appreciate your argument. I mean, it's interesting. I'm constrained by the law, though.
I appreciate your argument. It's interesting, but I'm constrained by the law. And KJB says, Peter, I wonder what the prosecution thinks during this long argument. It's kind of fun sometimes to just sit there as the lawyer and listen to the other side argue on and on and on, knowing that they're going to lose and you're going to win. So you don't even care. You're not sweating. You're just waiting for the judge to say exactly what the judge just said. Alicia A., this is kind of the wild part about this. If it was dismissed, would the state just do a preliminary hearing? Well, even better. If it's dismissed, the state could just refile and do another grand jury. And maybe now say beyond a reasonable doubt, or they could do a preliminary hearing. So yeah, that's kind of the point, is even if it gets dismissed, it doesn't mean this case is over. Destiny said, Peter, do you think cameras will ever be allowed live in the courtroom? I don't think so. I think if there are cameras that continue forever in this case, it's going to be more like this. Azam, Peter, if both parties want cameras out of the courtroom, is it solely up to the judge to make a decision to allow cameras? All the best in your golf tournament. Watch out for the groundskeeper. So the judge also has to consider the media's rights and the public's rights and to balance that. And if you remember from some of the podcast episodes we did about trial by media, there's a lot of different constitutional rights and people involved, not just the two parties. The two parties are the most important voices, but they're not the only voices.
You're making a record. That's good.
Judge.
He said, you're making a record. That's good. So it does seem like this is for other things and not just for this motion here today.
Kevin just said, held some things. It's true. But nobody was arguing about that standard of proof. In fact, they stated while they're walking through what a grand jury is versus what a preliminary hearing is. That doesn't settle what the standard is. Just because they said it doesn't make it the law. I think their jurisdiction is limited. And yet, broader than the United States Supreme Court, although if you read that most recent opinion where Judge Stegner doesn't agree with anything about what their jurisdiction's like, it gets kind of complicated. But the point is, they can't just say in an opinion where nobody's arguing anything. Oh, and by the way, the law of the land is this. Nobody briefed this issue in essence. Nobody briefed it in any of the cases that came after it. They didn't set in stone via that opinion what the standard is. They tried by adopting the rule. The rule is the question. The court has to try to figure out, is it a procedural right or a substantive right? If the court says it's a procedural right, and essentially what the court is saying is that the courts get to decide how much it takes for one of us to be thrown in the lockup, put to death, etc. Which I can't find any case that has ever said that. They've all said that the standards being set by the Constitution or the legislature, setting these standards over and over and over again.
It's just kind of a repeated argument that doesn't hold a lot of water. Sarah M. Peter, I was rear-ended by a cop at a red light. He was looking down his computer. I've literally had this case before. It has happened. It stinks, man. And the report's never as great. It's usually a harder battle to litigate, but we've had it before and had really good results with it. So if you are hurt, it's not over just because it was a cop. So don't think that. And if you need treatment, get it, because if the accident caused it, you need to get the records to actually substantiate that. If not, if you're not hurt and it's just property damage, make sure you get everything done as quickly as possible. Take a bunch of pictures so that there's no argument later, because it can be difficult when a cop is the one at fault. Lady Losandra, Peter, aren't we supposed to use the most recent cases? Not always. As long as a case is still good law, meaning it hasn't been overturned by the Supreme Court, then you can still use it even if it's older. If those principles still exist or still are the good precedent and good law still today, you can use older cases. But if they've been overturned or the Supreme Court says, no, these are wrong, then yeah, you can't use those cases.
So for the Idaho Supreme Court to issue a rule setting the standard of proof, even though there is a statute that says otherwise, they can't do that. That didn't become something that, they did it, but the court is in a position to consider whether or not they could do it. The court can tell the Idaho Supreme Court's rule isn't constitutional. Courts can do that. We consider bail issues. We consider bail and appeal, things like that. Statute versus procedural rights. Those things occur. And the lower court can look at that like anybody else can. Who's in the right? Is it the legislature or is it the court? So I think the court can decide all these things. But if the court's going to say, okay, I hope you'll at least write a 32-page order in which you explain how right I am on everything except that. Okay.
He says, I hope the court will write a 32-page order on how right I am, except for one little thing or whatever it may be, or basically I have to argue it up to the Supreme Court. Basically, he wants the court to say, all of your arguments are correct, but I'm bound by what the Supreme Court says, so that he can use it and take it up. I don't think the court's going to do that. We'll see. Elfin Madness, I've seen your name pop up a couple times. I don't know if you're like upgrading your membership or if you're a new member, but welcome. And Netwoman enters the chat with a storm like she usually does, gifting 10 memberships. So thank you, Netwoman.
I'll work on that. Thank you. I appreciate the argument. I think it's really creative. And I appreciate the journey back through history. I think it is an important factor in determining what the law is and why the law was established the way it was. But even you, okay, and I've heard this, but even in your brief, and this is your quote.
This to me is like, this is brutal. And I read it and did the same thing Judge is going to do right now on my video, so I can't blame him. But he's literally reading a quote from Jay Logsdon's own filing.
Okay, that the whole of modern jurisprudence on the issue is against it, as well as the least one founding father of this state. So
it's like when you have to put that in motion, you know you're going to lose as a lawyer, right? There's a lot of things lawyers can do. Overcoming that is not one of them.
I get it. I mean, what it comes down to me is that I am constrained by what I believe is settled law in Idaho. I may be wrong, but this is certainly an issue that you would have to bring up with a higher court, like the Idaho Supreme Court, and I look forward.
Everybody in the courtroom knows that, by the way.
To getting that from your perspective settled in Idaho. We'll see. There's the rule, of course, which, as we've talked about. But this argument really is fighting against some case law too. You may say that it's all dicta. I mean, that's debatable, I suppose. But the Idaho criminal rules, specifically Rule 6.5A, expressly states that probable cause is the standard, not beyond a reasonable doubt, and for a grand jury's indictment. And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion in the argument. So I am going to deny that argument. I think.
So Elfin said she is a new member, so or he or she. So that's awesome. So a lot of times he has reserved ruling, but this time he's wasting no time telling us motion denied. I will enter a written order, though. It's probably not going to be 32 pages.
The argument is, I am going to deny that argument. I think the argument is good, but I can't go that far. Not today. I'll give you a written decision. I can't guarantee it's going to be 32 pages. It might be longer. It might be shorter. So we'll see. But it's always enjoyable to have an argument with you, Mr. Watson. So I think that's all we have to do still. Ms. Taylor?
That's it for today, Your Honor.
Okay, and Mr. Thompson?
Yes, sir. We're done for today.
Okay, nothing else to address then. Okay, well, I hope you all got a touch of Idaho history and the law and how it works and our Idaho and United States Constitution. So go out and learn some more. Okay, thank you all.
It's like it's kind of a grin for everybody except for Brian Kohberger. He's like, I hope everybody enjoyed that little history lesson. Hope you learned a lot about Idaho law. So I am glad that we were able to get this done here before all the trials started. I'm going to answer a few more questions before we head out, but right after this is over in about 8 minutes, we're going to premiere my thoughts on all the wild stuff going on in Delphi. So if you want to check that out, because court usually starts late anyways. Lisa, welcome to the membership crew. LS, driving across country to Florida today. How's the weather? Literally perfect. Sunny and like 75 right now, going to get up into the 80s. Pity Mom. Peter, so the Supreme Court, is the Supreme Court the final authority on those rulings? Can the Supreme Court rulings be appealed to a different court or authority? Yes, they are the final ruler or final authority, and they can overturn some of their own past decisions. And sometimes that happens because there are different Supreme Court justices over time, right? Somebody 50 years ago is probably not on the Supreme Court anymore. So they can overrule their own decisions. But sometimes what will happen is a lower court will disagree with the Supreme Court, and then it would have to be appealed up to the Supreme Court. And the other side that could appeal it up to the Supreme Court, and the Supreme Court would have to say, are they actually right? So there are ways to get questions to the Supreme Court, and they can either confirm what they've already said or change their mind. But it's very unusual for lower courts to disagree with the Supreme Court. Netwoman has gifted 20 more memberships. She's like building an army here, a lawyer, membership army, which is awesome because the members only lives then grow and they become so fun. And we're already talking about what we're going to do for November. We've done some holiday themed ones in the past. Maybe we'll do a Thanksgiving theme one or something like that. Azam, thank you so much for the super sticker and for gifting a membership as well. The membership stuff is really fun. We've done a couple this month. We've done some late night hangout ones too, as well, just where I'm like on my phone sitting outside somewhere. I really want to have Whitney on one of those. I know you guys do too. So I will get her involved to answer some questions that you guys have for her. Netwoman, 20 more. This is not a repeat. This is another 20 memberships. Wild. It's so wild. If you hear that, I'm at the end of my coffee. I think I need a little charge up. So here's what I'm going to do. A lot of you guys asked about Sally Smith. I'm going to go record a quick, probably 1.5 speed on her proffer, which was the most heated part of the Maya trial yesterday. And I'm probably going to post it during the lunch hour. So anybody watching the Maya trial could check that out. I'm going to continue following the Dan Markell, Charlie Adelson, Hitman trial. And we will continue to answer all of your questions on Kohberger and Delphi and all that. I'm going to try to keep up with as many cases as I can. You guys are literally the best. I appreciate you so much. I appreciate the questions. I appreciate the gifted memberships and all this stuff just to kind of keep the family stuff growing. So stick around here. You're going to be redirected in about 5 minutes. The next video is going to start. Please let me know what you think. Hit that like button on this video before we end. And then right when you get jumped into the next chat, hit the like video over there, or the like button over there. Subscribe if you haven't already. The Petito case, yeah, I'm still following the Petito case. It's in the drudges of civil litigation. I saw some motions to compel testimony about between Brian Laundrie and Bertolino, and they're protecting that as attorney-client privilege. And we're going to have some arguments of whether the attorney-client privilege lasts after death of the client. My understanding is it does, and that it's the client's privilege to waive. And if he doesn't waive it, then that stuff should be protected. We'll see if they get around that. So there's a lot of stuff happening. The Tragonators, I call my son Navinator all the time, so it's funny that you said Tragonator. But yes, that's all we got. You guys are the best. I appreciate you so much. Netwoman, Peter, thank you for doing a highlight in the premiere videos so that we know it's not a live. I always try to do that. Because I know people get frustrated when they think it's a live and it's not. So I try to make that as clear as possible in the title. So always check that out. The next one coming in about 10 minutes is a premiere. The Sally Smith thing will be a premiere because I'll be playing golf when you're watching that. So hope you guys all have a great day and a great weekend. But until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouknow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You